Power of attorney. So, as an introduction, a power of attorney is a legal document by which one person, termed the donor or principal, authorizes another person, termed the donee, attorney, or agent to act on his behalf. So, to provide a power of attorney, there must be two persons, the donor and the donee. And the donor is also called the principal. Donee is also called the attorney or agent. So, this is an introduction to the power of attorney. Now, let us see the importance of the power of attorney. In the case of an estate planning of a person, power of attorney is extremely important. And what happens is when the common man is concerned, common man thinks that the power of attorney as well as a will is the same. When a person is issuing a power of attorney during his lifetime, and if that person dies, people are under the impression that the power of attorney or the authority given under the power of attorney will continue even after the death. It is not like that. And will is a document by which, after the death of a person, his property is distributed in a manner as desired by him. That's the difference between both these documents. A will comes into effect on the day a person dies. A power of attorney applies during a person's lifetime and it ceases to apply when he dies. So, as a legal professional, we must understand clearly the difference between the power of attorney and the will. Will is after the death of a person, and power of attorney remains during the lifetime of a person. And the power of attorney must be executed and authenticated by the registrar or the sub registrar as per the Registration Act 1908. And there are two types of power of attorney. First one is the general power of attorney, which confers a general power of performing. When it comes to the special power of attorney, only a specific power to perform a particular act or task is given. For example, maybe one particular property, 10 cents of land, which is to be sold by one person to another. And for this, a power of attorney may be, a special power of attorney may be issued. The special power comes to an end once the task or the specific act is done and is always work specific. You cannot create a special power of attorney for many acts. Then comes the classification of durable and non-durable power of attorney. Usually a power of attorney comes to an end with the death of the principal. But if the principal wants the power of attorney deed to continue even after his death, then he has to mention it in the power of attorney deed. Such a power of attorney is termed as durable power of attorney. And when it is not mentioned that the power shall continue after the death of the principal, then it is a non-durable power of attorney. All the power of attorney deeds are considered as non-durable and ceases to exist with the death of the principal. And let us see what are the clauses which are included in a power of attorney, or what are the contents of a power of attorney. The name, age, address, and occupation of the person who makes the power of attorney, that means the principal. And the person to whom the power is granted, the attorney or the agent. The reason for granting the power of attorney, which is legally valid. Then the date and place of making the power of attorney deed and the date from which it comes into force. The date of termination of the power of attorney if it is limited by time. Then if no time is specified, mention whether the power of attorney is durable or non-durable. If it is a general power granted, then all the acts and areas of granting the power should be mentioned clearly. Suppose it is related to a property, maybe related to the sale, management of the property, renting out the property, everything you have to mention under the general power of attorney. And whether any particular act is not to be done by the attorney in certain areas, that must be specified. Whatever is restricted, that restriction also you can add as a condition. And in special power of attorney, the specific or particular act or the task that needs to be done and completed by the attorney is to be clearly mentioned. So what is the specific task which is to be completed through the special power of attorney? That must be mentioned. And also the time limit within which that act is to be done also to be mentioned. Then let us see the powers. By the power of attorney, it may be executed by two or more persons jointly in favor of one or more persons. And when there are several persons as attorneys, a complete authorization in letter to be given by one of them who acting severally. And a clause should be included or a condition should be included while drafting the deed of power of attorney that all the attorneys should act jointly or separately. So how the action is to be done by the parties is to be clearly mentioned, whether jointly or separately. And let us see who are the persons competent to execute. A power of attorney can be executed by any person who is competent to enter into a contract. In the case of a married woman, she can execute a power of attorney even if she is a minor. When it comes to a company, while issuing a power of attorney, it must be in conformity with the Articles of Association and the common seal of the company. Articles of Association is the bylaws of the company in which all the internal affairs of the company will be clearly mentioned. And a person must be competent to give power to the appointed person so that it will not affect the legality of the instrument or deed of the power of attorney. Then comes the authentication of the power of attorney. As a legal document, a power of attorney is to be properly framed using the correct legal terminology and setting out the objectives and responsibilities to authorize the person to carry out on behalf of the principal. And it must be signed and notarized by a certified notary advocate who is able to declare that one is competent at the time of signing the document to issue the said power of attorney. So it is the notary advocate who is mentioning or who is authenticating the power of attorney by looking into the competency of the person who is making the power of attorney. Then the question arises as to whether we can revoke the power of attorney. That means whether we can withdraw the power of attorney. It may be revoked at any time by the principal or the donor by giving a written notice to the agent, unless it is for a particular fixed period. And withdrawal of the power of attorney is possible when principal dies, becomes insane, or becomes a bankrupt or a pauper. The principal himself can revoke the power of attorney if the business for which the agent was appointed is over as mutually agreed upon by them. And in case if principal has named his spouse or a registered domestic partner as his agent, his or her authority to act under the power of attorney is automatically terminated or comes to an end in the event of divorce, legal separation, or termination of the registered domestic partnership. So this is also one point we have to remember. And when it comes to the registration of a power of attorney, it's not compulsorily registrable unless it creates an interest in any immovable property. That is a charge in favor of the donee. When the Registration Act is prevailing, the power of attorney should be authenticated by a sub-registrar only. Otherwise, it must be properly notarized by the notary, especially wherein power to sell land is granted to the agent. And if it is in respect of an immovable property of value more than ₹100, it must be registered. Registration authenticates the deed of the power of attorney. And when it comes to stamp duty, it's chargeable under the Indian Stamp Act 1899. That means when we are preparing or drafting a power of attorney, it must be done on a stamp paper and to be paid compulsorily by the principal or donor in the jurisdictional registrar's office. Now comes the format of a power of attorney to execute a sale deed. So this is given as a sample. We have to start the document by the words, by this power of attorney, I, that means the principal, his age, his parentage, his address, everything we have to mention. Ask my attorney to act in my name and on my behalf and do or execute all or any of the acts or things hereinafter mentioned. That is to say, so whatever we want to execute through this particular document, we have to mention here one by one with consecutively numbered paragraphs. And this is connected to the sale of an immobile property. So what all things you can do connected to this, you have to add in the form of paragraphs one by one, consecutively numbered. Then after all, on I do hereby agree to ratify all acts, things, deeds, or proceedings lawfully done by my said attorney on my behalf and in my name by virtue of this power of attorney, and the same shall be binding on me in full force or effect. Then in witness whereof I have executed this power, and the date we have to mention. And when it comes to a legal document, the date is very, very important. From the date which is mentioned in that document, that the particular document will be coming into force. The schedule above referred to. So when it is related to a immobile property, we have to describe that property in the form of a schedule attached, then signed and delivered by the within name the executant. Then witnesses also have to sign. Then identified by me, before me, the name of the advocate, notary public also you have to mention. So these are the things which you have to remember when it comes to